Hey, right, everyone. Welcome to this week's live streams. Give us a minute just to do the usual admin stuff back here. Um, as always, this ain't legal advice. We're going to try our best here to be helpful, but can't guarantee it all the time. Sorry, just got to try and find these different screens. Here we go. So yeah, so that's first thing, not legal advice. Second thing is please don't share personal data in the live chat. Just ask questions as what if questions. So the questions we've had in for the week generally are basically following that advice, which is good, helps us out. Just going to pin that for a second. I think that's everything. Hold on. Done it all? No, not quite. Here we go. Yeah, cool. Right, yeah, cool. So yeah, I hope everyone's doing all right this week. It's obviously, I don't know what's like your area of the country, but it's really weird and muggy in Bedford, and I've had enough of it. I've been boarding a loft and insulating a loft a week, and it's done my head in. So yeah, we've got about 5 questions that are coming through the week. Yeah, anyone got any news? I know Shannon, you were talking about DHPs and potential changes that are coming in. Obviously, not full details yet, but yeah, what have you heard?
Yeah, so where we used to have the household support fund, it's now being sort of redone as the crisis and resilience fund, but within that, DHPs are going to sit. Um, and so part of the work that the DWP is doing, reviewing obviously all of this crisis and resilience fund, and it's all going to be co-designed with statutory organisations, third sector organisations, and people lived experience. Is the redesign of sort of DHPs and sort of assessing like how long councils get funded for DHPs, the scope of what they could use it for. Because I think at the moment the technical criteria is quite strict to whether opening it up is helpful or not. And there's a big focus on prevention within the crisis and resilience, and I think prevention will feed into the DHP. So it might be the case, be the case that people would be able to get DHPs potentially earlier, potentially for longer. Those are some of the positive changes I think I'd like to see anyway. But yeah, I think they're planning on they're working on it now, and the plan is to be quite quickish with it, but they want to do like they're working hard on it. I think winter this year is potentially when we're going to hear a bit more, but yeah.
Cool. And you were saying that part of the rationale is that a lot of councils aren't spending their DHP budgets as it is, which is
Yeah, so
interesting.
yeah, and like you can see all this on like the government websites because they recently published like which local authorities have spent how much as well. And lots of local authorities had loads left in their budget. Um, Whether you could argue that that's because they're planning for summer and they normally see in their local area more DHPs applications in summer, or I don't know, but it is interesting to see. I think particularly as well, and I don't have a brain for numbers, so Mike, you might be more interested in it. But there's probably some like links between homelessness or TA and the amount of DHPs going on in a local authority and stuff like that. So yeah, far more interesting than I can get my head around, I think.
I'll have a little look. I think I have vaguely sort of come across those figures in somewhere in the live tables before, but I didn't pay much attention to it. But yeah, cool. Yeah, keep us posted about that because I guess it's going to make quite a big difference to people. Any other news? Anything else going on of significance in the homelessness sector or anything like that? If not, we'll get into the questions. Uh, you are Tiff. You're not late. You were saying apologise for being late. You're 4 minutes late. It's all right. You're right, Michael. One thing I did actually a little bit not that interesting really, but YouTube has started telling me when people ask questions whether they're subscribed or not, and I was surprised by how many people aren't subscribed. So if you're asking questions and you find it helpful, please do subscribe to the channel. It does support the channel. It basically helps the algorithm out, basically, and all that sort of thing. And also along the same lines, if you find this video interesting, give it a like. That's helpful as well. But yeah, let's get into the into question one. So here we go. Let's get the one first lined up. So here we are. Let me just make that look all right. It's looking weird. There we go. So yeah, if the council are trying to house someone with severe mental health and substance use issues with a history of breaching licenses, can they just refer them for an assessment at a supported living provider, Salvation Army in this case, without asking their opinion? So this is interesting question. I guess we're talking here. Hey, right, so back. We're talking partly here about data protection stuff as well as as kind of Housing Act and relief duty, that sort of thing. Because it's an interesting question. I'm not actually sure I know the answer to it. Because when you make a homes application, I'm getting to the answer by the way. But when you make a homes application, the reason for the council, the reason for processing your data is not the fact you gave them consent. Technically, they should not ask you for your consent. That's a whole other story because they're a local authority. It's very difficult to get genuine consent. But they're basically processing your data on the basis that they have a statutory duty to make inquiries into your case. But you can still object to that, and you still have you still can effectively you have control over your data because you can withdraw your application. Now that's kind of like usual sort of Section 184 stuff. Now, when it gets to Section 189B relief duty stuff, when the council's assessed your situation, they've basically done a kind of done a personalised housing plan, and they might have identified that because of someone's support needs that they would be the council's opinions they'd be better off in supported accommodation. I don't think that my opinion is they can't just refer and share your data with a random organisation unless you know about it. That would be my position. However, there was a case a few weeks ago which I picked up on the LGO website. I did do something about it, some this live stream. But basically where the complaint wasn't upheld because in effectively the homeless applicant, the person had agreed to the personalised housing plan. So in that case, the personalised housing plan said the council will refer you to supported accommodation in the area. And the person said, yeah, fair enough. And then the council went and did that, and the person didn't like who that data had gone to. So they complained about it, but the LGO didn't uphold it because they said, well, you'd agreed to it. So I guess the question here is, I think the answer is without asking their opinion, I think that would make it unlawful because the whole point of like processing your data is if it's not consent you're relying on, the person still needs to know what you're doing with it and still has a right to object to it. So if you haven't asked them, if you haven't told them you're going to go and do it somewhere, then I'd say it's potentially a breach. Shannon?
Yeah, I think just to make the point that, and I don't know about the specific LGO case that you made, but lots of people will end up with PHPs that are signed and agreed, but actually they don't know what's on there. Or the housing officer has added things later on. And so it's always worth checking your PHP before you sign it, making sure you're genuinely happy with it and getting a copy of it at the time of signing as well. Yeah.
Yeah, and we see it all across the homeless sector where workers basically shove a consent form of some description in a client's face and says, right, sign this, and they do because they're not going to sit around reading the small print every time, and they don't actually realize what they've just signed. And so yeah, I think it's just kind of all the more important just to kind of register that when you're being asked to sign something, that you are actually you do know what you're signing because yeah, basically if you sign something saying the council can go do something and it goes and does it, you can't really then complain about it very easily. So yeah, I think that's it's an interesting question. I might well return to it. If you're watching the channel this week, I put a couple of videos up involving data breach stuff, and that's because Bedford Borough Council basically finally paid the client in this case, and I have a lot more to say about it. So because for me, data protection is essentially one of the most powerful tools that members of the public have, like just to basically hold councils and other organisations to account. So I will be kind of talking more about it in future. But yeah, I think that's it. I mean, I don't know if anyone else got anything to add to this question at all. If you do, Will, you're on mute.
Sorry, can I just jump in? I'm sorry if I'm missing the point here, but I was reading this question not in terms of data protection, but just in terms of suitable accommodation and suitable way of processing and housing somebody. So could I just have a little rant about that?
Yeah.
Because so if they're trying to house someone, I'm assuming it's because someone has asked them for help with housing. I mean, or they've been referred. So that would trigger, in my opinion, that might be a Part 7 application. So they're applying as a homeless person, So you can't, in my opinion, just because someone has severe mental health and substance use history and history of breaching licenses, it doesn't mean that they're sort of condemned to a life of being shunted into supported accommodation. And it may be that that they can live in ordinary accommodation with appropriate levels of support. Particularly because the ironic thing is that supported accommodation often leaves them in an environment which is detrimental. Not because of necessarily they've got a sort of authoritarian regime that might evict them just for sort of saying the wrong thing, but also that there's people running around making a noise and doing lots of drugs and stuff. So I would have thought, no, they can't do that because they have to demonstrate that it's suitable and they have to demonstrate that they've carried out a proper assessment. And it may be that a proper assessment would lead them into supported accommodation, but it's not inevitable. And I think it should be challenged because I don't see why somebody who has mental health problems and maybe has overcome their drug use and are not likely to breach the terms of the tenancy shouldn't be given the same chance as everyone else and given accommodation and support. Because there was a time, you know, when they closed all the mental hospitals down and they said it would be there. Do you remember the term was care in the community? And so the idea is that people should be able to play a part in it. I mean, it was always a bit of an empty expression, but the idea is they should be able to live in the community. So I'd say challenge it and don't resign yourself. Just as soon as you have the words mental health, that means open the trap door and send him off to the supported place. So that's my rant about that.
No, I think so. If we actually put this question alongside another question we got asked, it's actually I think asking a very similar thing. So we'll come back to question 1 as well, but just we kind of put it next to question 2 as well. So what if the council straight away refuse to provide interim accommodation but want to send the homeless applicant into a YMCA even with lots of medical evidence? Also, if the letter says you can, yeah. So we'll deal with the second part of this question afterwards. But basically, same kind of thing where you make a homeless application. The likelihood is the council will owe a main duty to that person, but instead the council basically try and palm you off to a supported accommodation provider. Now, I mean, I don't know if there is the stats out there. I'm absolutely convinced of this. I'll die on this hill any day that for most people, supported accommodation is that you actually got a lower chance of success of maintaining supported accommodation than you do in your own accommodation. Part of that's because you've got a tenancy in your own accommodation rather than a license, and part of it is because supported accommodation tends to have loads of rules that are quite difficult to meet when you're stressed out, whereas your own tenancy doesn't generally have the same level of rules. But yeah, I'll draw on a case I've talked about before a couple of times to illustrate how this might work. So in fact, I'll give 2 examples. So one involved a victim of modern slavery, and we'd made a homeless application to Bedford Borough Council. We had a really ropey housing officer, and there was some messing around like gatekeeping at the start of it, but we got him into interim accommodation. And then and yeah, once we made inquiries with the national referral mechanism and various other kind of agencies involved, it was very clear he was going to be in priority needs. And I think as soon as the housing officer realised that, she started strenuously trying to get him into supported accommodation. And she similar kind of case there. Basically, she referred him to a local mental health supported accommodation provider. And I said, hold on, what basis have you done that? You've not told him you're going to do that. So it kind of relates exactly to the kind of situation in question 1. And at that point, the housing officer immediately changed tack and accepted the main duty and housed him, and he got housed in social housing. And in another case, again, where it was almost, it was about certain she can be, this guy was going to be in priority need. Again, as part of the PHP, the council tried to refer him to other organisations. One of the organisations accepted him. And we basically said to that charity, it was a half decent charity, we said, look, we're waiting to see if this guy's owed the main duty. Can you just keep him at the top of the list until he knows for sure? And kept that kind of running on for a couple of months until the council had to make the final decision, which was he was owed the main duty. And again, he got social housing. So those kind of situations speak to it a little bit. I think the problem with question 2 in particular, or the question 1 relates to it as well, is that we come back to this kind of problem of councils perversely finding people not in priority need when they clearly are, and kind of using that as a kind of as a leverage to try and palm people off. That's kind of the power play there. They'll kind of say, well, you know, we don't think you're in priority needs, and at this point in time, you've got no right of review because you're still in the relief duty in terms of that decision about priority needs. And so you kind of, you know, unless you've got a competent advocate who's willing to kind of evidence why you're in priority need, it's quite difficult to win that. You're kind of in the situation where the council will make out like you know, you've got basically their way or the highway sort of thing. You know, bird in hand is worth two in the bush, to use lots of whatever these things are, metaphors or whatever. So yeah, I think that's what that's what I'll be focusing on in a situation like this. I'll be focusing on showing the council that this person is in fact in priority needs, and basically making sure the individual understands that they don't have to accept supported accommodation. And there is, as I say, there's no logical reason why they can't just hold, you know, kind of wait until later on in the process to actually accept this support accommodation. So they can wait until the final decision's been made and then say, okay, yeah, well, the answer is no, I'm now going to accept the support accommodation. There's nothing stopping that unless the support accommodation provider is absolute dog, yeah, kind of horrible people basically who are just kind of trying to do the council's bidding. So I think that kind of answers questions 1 and 2A. In terms of 2B here, so if the letter says you can add yourself to the register with the above link, but the link sends you to the assessment again, how to get on the register. So this just sounds like a council being incompetent. So they've obviously got a system which doesn't work properly. And anyone, just to make the point, anyone who's owed either the prevention, relief, or main duty, and I think also the Section 190 duty for those who are intentionally homeless have to be they have to get reasonable preference on the housing register, which means you have to be able to get onto the housing register. You need to be able to bid. So councils don't have, they have to have a system which allows that. If the council system is rubbish, then you basically raise it politely initially. I would just go back to your housing officer and say the link doesn't work. And if you don't get a response very quickly, then I'd be looking at making a complaint, because it's not just you that's going to be affected by the link not working. It's probably everyone else as well. So having said all that, just because you can get on the housing register doesn't mean to say the council can't make other offers of accommodation and basically end the duty that way. So they can still make a final accommodation offer, which is an offer of private rented accommodation, and there's nothing you can do to stop that. So the fact you might be on the housing register doesn't guarantee you're going to get social housing at all. It just means you're on the housing register, and in a lot of places that gives you no chance at all, whereas other places you do. So it does vary massively around the country. Cool. I think, yeah, so hopefully there's I will be returning to this issue of the data protection implications of these kinds of situations, but for the time being, I think what we've said there will be helpful, or hopefully will be helpful. So yeah, that means the next question from the week, and just to say thanks, guys, to people who are submitting questions in the week. It just makes it so much easier just to kind of keep track of it all. So yeah, and double thanks for anonymizing these questions. So it's really helpful as well. So a person submitted a properly written formal stage 1 complaint to the council. The council missed the deadline, so the person escalated to stage 2. Well done, that's a good thing to do. Is the council more likely to take it seriously at stage 2? Absolutely yes, but still, like lots of councils will just kind of, hold out for the LGO stage. So it's not going to guarantee it, but they're more kind of likely to give a reasonable response and offer a bit of money. You see a lot of LGO decisions actually where the council offered like 300 and the LGO say no, 2,000, and so the council tried to kind of they sort of tried it out and just see if they get away with paying out less money. The person also received a message from the councillor who is quite high in position, and the councillor said that he emailed the department with the council to ask for both a response to the complaint and also a response under section 202, which is now more than two months overdue. Can the councillor help with this case? In the real world, absolutely yes, they can. I'm actually not quite sure what their remit is, because they're not, I don't think they're supposed to actually get kind of into the nitty gritty of decisions or the kind of processes within the council, but they can. But they can obviously add scrutiny, and I think it's absolutely like legit to chase letters. So although they can't, I don't think they can have any kind of like hand in the actual decision itself. They can certainly get the council to comply with the process. That's my understanding of it. So yeah, and certainly in Bedford, a number of councillors are very proactive with that sort of stuff, and certainly Bedford as an example, when a query comes in from a councillor, particularly one of like the big kind of parties, sort of one of the big three, I think they get taken much more seriously that way. So I always say it's good to get a councillor involved. Anything you want to add to that, guys? If not,
Can I
we'll
just
go on.
jump in and say that if the Section 202 review response is more than 2 months overdue, then you should be looking at appealing to the county court, because if they don't complete it within 2 months, you can then do that, or 56 days, which is slightly less than 2 months. Yeah, then you can appeal to county court, or threaten to do that, and you probably get them moving if you send it to the legal department as well. But if not, just issue it, and it's likely to eventually lead to them completing the review if they weren't already going to.
Cool. Thanks, Will. Question 4. So again, this is on one of the data protection videos I did. So that's why we've got a couple of questions about data protection stuff this week. So councils hire companies of dubious character to manage homes where vulnerable people live. Absolutely, they do. Yep. Well, hire is probably an interesting, probably not the technical word, but yeah, yes, they do. These companies use information in unimaginable ways. Yes, they do. Ask compensation to the council and the company, or both, because if we analyse it, the council is responsible since it was the first to have access to person's data, right? Yeah. So basically, the way data protection law works is you've got really any organisation that we're talking about will be a data controller. So the council, a charity, a support accommodation provider, they're all data controllers, and they're all responsible for their own stuff. But there is also a requirement. I think there'll be an argument to make to say that if a council sent data to a dubious company or something, then the council would, and then the company then did something bad with it, then the council would be liable to some level with that. So I think if you've got a situation where multiple organisations have breached the law, you'd have to take on each individual one yourself, kind of individually. I'll give you an example of this, although I didn't make use of this back then. So one of the first data breach complaint I got upheld was for a guy who applied to a charity. It was Mayday Trust. Mayday Trust seemed to have a default policy that they would ask for a police national computer check for everyone who applied there. And the information that came back from the police was that this person had been convicted of one of the following. One was a Schedule 1 offence, one was like possession of drugs, one was like violence or whatever. And the actual his offence was burglary. Not even like kind of just really stupid burglary, but basically the Mayday Trust staff then concluded that he was a Schedule 1 offender, which was not there. He wasn't. But then they passed this information back using Bedford Borough Council's system. And that then kind of fortunately it didn't actually lead to much harm because we managed to stop it. But in that situation, Mayday Trust were the ones who paid compensation. But probably if I knew then what I know now, Bedford Borough Council would also have some liability for how that data was shared and accessed by other people. So that one example of how this might work out in the real world is that if both organisations, both controllers done something wrong, then they would be liable for they'd be answerable for that. So the answer is yes. But that's quite a long way to get to it. Anything else on those questions? That's the 4 that have come in through the week, which are anonymised. We've done those first. We then get across to the ones in the live stream. So I'll start piecing this one together. It's a multi-parter. Just to say again, guys, one of the reasons why you're better off submitting questions in advance is that it doesn't involve me messing it up by missing something, because if it's all in one place, there's no character limit on the channel rather than the live stream. So you kind of, it's just gives you a bit of an advantage. Sorry, my computer's now struggling to copy and paste stuff. I think this is it. Let's double check. Yeah, it looks like it's it. Okay, so question 5. Someone made a homes application in January and was placed in interim accommodation by February. Despite providing all evidence, autistic male, mental health, suicide ideation, such as OT reports, etc., he didn't hear anything until the 5th of June. No, is that what it means? A month later now in July, or 5 to 6 months later. Sorry, yeah. Now in July, after making a complaint that the housing team has failed to make a final decision in a reasonable time frame, when he did hear back from the housing officer's manager, he was just given an allocated direct offer straight away, rather than being put in temporary and given an opportunity to bid. Is this lawful? Must he accept this direct offer even if he doesn't meet all essential needs, being an autistic male suffering from severe mental health and anxiety? So if we omitted that last sentence, then it would be legal for a council to make what's called a final accommodation offer or a final Part 6 offer. So final accommodation is private rented, final Part 6 is social housing in the relief duty stage. And if you refuse it and you don't have a good reason for refusing it, then they can end all duty to you. However, in this case, we don't have enough detail here to know for sure, but if the council can't show that they've carefully considered this person's disabilities and made sure that the property that they've offered is going to be suitable, then it would be fairly straightforward to challenge. And so in one sense, the council would need to have a record somewhere which explains, what their rationale was for concluding that this property was suitable. Which most councils, certainly councils I've dealt with, they don't even have training on the Equality Act full stop, so they are at a disadvantage to actually follow the Equality Act legislation and the impact on housing. So yeah, so the answer is, what we're always going to say is that you should accept any offer of accommodation and then challenge it rather than trying to challenge it first, because if you lose the argument, you are done. And even if you've got a really good solicitor involved, it's going to take months and months to get it ironed out. Whereas if you accept it, then at least you've got somewhere, and then you go about challenging the suitability through a Section 202 process initially, which can be done without a solicitor. And in one sense, it may well be that you've got stuff in the OT report which basically says this person needs X, and then you say, well, this property doesn't have X, and therefore the property is unsuitable. That would be, the kind of way to go. So, but I'd be surprised if a ordinary housing officer even kind of knew anything about this stuff. Really, they they just don't get training on it and stuff. So it's generally quite easy to challenge. But as I say, I think the answer is accept it and then challenge it rather than trying to challenge it first. But it's, on the face of it, there's a very, very plausible that the challenge will be successful. Anything you want to add to that at all, guys? Just to say, guys, any personal data in the live chat, I'm just going to delete. So you can ask questions, but if you notice how these questions are phrased, they are all what if questions. They don't actually kind of disclose any personal data at all. So please just use them as a kind of framework. The best way to ask a question is, what if this happened? What would the law say? You're going to get the right answer. Let me just check I've not missed anything. So yeah, so just that question about clarifying what Shannon said at the start. No, so it's not saying that the DWP have been telling councils who can have DHP. Every council has a DHP budget. So yeah, but there's going to be changes in how it's all kind of run. You're right, Chedology. I don't think I've seen your name before. Welcome. So next question, again, multi-part, just bear with me. So you just to clarify, guys, when I say asking the question on the channel, if you go on any video on the channel in the week and you ask your question, there's no character limit. I get a notification that you've asked the question, and then I'll basically answer it first in the live stream. So it just makes it easier for everyone, I think. So just, yeah, you can use a live stream, don't get me wrong, but it just seems to be better to do it the other way. So number 6, how long the council should take to make a decision about the review of a decision? The family asked for review as prevention duty was accepted after Section 21 notices expired and landlord started eviction process. 3 months after waiting, still waiting for the decision from the council. Okay. I'm trying to think. Review of the prevention duty. I don't think you want to worry about that right now. What's more important is that they accept the relief duty. That's the important thing. Now, we've talked extensively on the channel before about kind of Section 21 process and kind of at what point you become homeless. So what point the prevention duty goes into the relief duty. There was another case this week in the LGO, kind of like the weekly updates or whatever. There's another case which is actually quite helpful as well, just looking at how the council got it wrong. But yeah, essentially the criteria is if the if the Section 21 is valid and the council doesn't believe there's any chance of getting the landlord to change their mind, and there will be no defence in court at that in the possession stage or whatever, then it's likely that the person will be homeless. Therefore, they should be in relief duty. The prevention duty doesn't have as much teeth as the relief duty, so you're better off in it anyway. So probably, I'm not quite, as I say, I'm not quite sure like the review kind of process, how it would work because of the time frame. It would probably be better that you effectively write to the council officer now and say, I think I should be in relief duty. And then if you don't get a response within a day or two, personally, I'd probably complain and just kind of just raise it and just get them to have a look at it properly. I don't think the review process is going to be particularly helpful in the prevention stage. There are things you can get reviewed, but as I say, it's pretty toothless at that stage. I don't think it's worth kind of the fight. Whereas the relief duty, because it potentially comes alongside the inter-accommodation duty, and because we're talking here about a family, which I'm assuming involves dependent children, then the interim accommodation duty will kick in. So I think that's my answer. As I say, I think it's not actually answer the question, but I think the better response would be to pursue the relief duty rather than kind of arguing about whether the prevention duty should have ended or not. I mean, I think pretty sure the prevention duty can continue rolling on in this situation. So normally it'd be 56 days, but because the eviction's kind of happening, the prevention duty kind of keeps going on until the council satisfied you are in fact homeless, which may well have happened here already. We don't know the exact information. So, you guys want to add anything about that at all? No, cool. Where are we up to? Okay, so number 7. Oh, sorry. No, take that back. It's got personal data in it. So yeah, if I've removed your question, guys, just rephrase it. What if question? How long can a family stay in B&B? That sort of thing. Very quick question for Will and Karis. So I think it's a very straightforward one. For the solicitors to be able to fill in legal aid form, is it necessary to have the applicant's address on bank statements printed from banks? Surely utility bill is enough with 2 forms of voter identification. Karis?
Right. I would say, yeah, we need to see your name, that it's your account. So your name and address that matches the utility bills, everything's got to match.
Right. Yeah, cool. Because but basically legal aid are very strict on this stuff, and if you get it wrong, then you do months worth of work and don't get paid at the end of it. So yeah, thanks, Karis. Hey, Dora. Okay, right. So next question, and again, just a double parter. So a person submitted a formal stage 2 complaint to the council because of lack of response to stage 1. I think this is a follow-on from the question 1 or 2, whatever it was, 3 or something. If the council does offer a compensation, but it's a small amount, can a person simply refuse to accept it and then submit a complaint to the housing ombudsman in a hope of a better response? So first thing, I mean, this is all pedantic stuff, so it's good to be pedantic. The housing ombudsman, if we're talking about homeless application process, then it needs to be the local government ombudsman, not the housing ombudsman. They will refer you back to the right place, but the housing ombudsman's different. They look at kind of particularly social housing, but not just social housing stuff. So there's they have a remit basically where they can't kind of go outside the remit. So it's very, as I said, I think I've mentioned it before, it's very common for councils, once they accept they did something wrong, to offer a insignificant amount of money. And I've talked before and I've done videos about it, the LGSO's guidance to remedies. So if you search for local government ombudsman guidance for remedies, you basically get a framework. It's worth reading. It's really fascinating. You get a framework as to kind of work out how much money should be paid. And so let's say you're rough sleeping and you've been left homeless for 3 months without interim accommodation, then the LGO will recommend up to £350 per month that you're left homeless, plus a few other bits and pieces added in. So that you're looking at over £1,000. Now, if you made a complaint and the council said, yeah, we did mess up, we'll give you £250, you just basically proceed to the LGSO, and they'll basically say the offer wasn't enough. Here's what we should, here's what we recommend instead. So yeah, it's a good sign. It's probably it's a good sign that the council's accepted wrongdoing. But yeah, if you want the kind of the right amount of money, so to speak, then it's worth going further to the LGSO. Shannon?
Just a question. Do you, because I know with like normal, when you go to the other LGSCO, you have to like exhaust the complaints process and everything else. With this side of things, would you have had to have, say, replied to that and like made a counter offer and say, actually, no, I think this is the compensation, or can you take it straight to the LGSCO?
So if it's so we talk about stage two. I guess what we should say is final stage. Now, most councils only have a two-stage process. So generally, when the council give you a stage two response, that's their final response. And so you probably can say to them, look, this is low. This is what I think the LGO would recommend, and you haven't kind of met that. Therefore, I'm going to take it to the LGO unless you reconsider. That's probably a sensible thing to do, but you don't have to do that. You could just take it to the LGSO at that point, and the LGSO would look at it. As I say, it's a fairly common thing. Most weeks you see in the LGO newsletter thing, you'll see cases where they offered, as I say, they offered a few £100s, and actually they were owed a few £1,000s. So it's worth. In fact, our first LGO complaint we ever got, just us, the council offered. What do they offer? Yeah, they offered a couple of hundred, and the LGO went over and said should be 800 or something like that. I can't remember the numbers now, but it was actually interesting from a point of view of not only did it get the amount of compensation offered increased, but it also basically logged it publicly. So I'm not sure if this counts as a loophole, but if you get a council basically upholding a complaint, you can still take it to the LGO, and that has the benefit of basically getting it logged. The LGO might say we've got nothing to add. This was a reasonable offer, but then it's actually publicly, the actual complaint will be publicly available. Which, if you're looking to get kind of increase accountability for council, that's probably not a bad thing. So I think that's all the ones from the live stream for the moment. If we just go back to the ones that weren't anonymized from the week. I guess another advantage of asking the question during the week is that if you don't anonymize it, I will still bring it here because it's not linked to anyone's name. So number 9, how long and at what stage does the medical panel come into play? Part 7 application activated on the choice-based letting system, but restricted to 1-bed property when I need 2 second bedroom as my disabilities impact greatly on my partner in their sleep. OT report medical evidence supports this, but currently the council are holding up their process and it's frustrating. I can't bid on suitable 2-bed properties as required. By necessity rather than choice, and feel pushed to bid for what I know to be unsuitable. So again, best source of information would be I need to update. So I've got a whole load more LGSO cases to upload to send over to you. I'll do that in the next couple of days, because one of the ones recently I saw was this kind of idea of like, kind of carers and kind of bedroom allowance and stuff like that. And it was just interesting how the LGSO considered it. But I think this would be a situation where I would, personally, I would go to a counsellor, kind of local counsellor, and basically say, look, this is the situation. I'm owed the main duty or whatever I'm bidding. My OT has said that I should have 2 bedrooms because of the carers' needs or whatever, and they're only saying I only have a 1-bed need. Can you do something about it? And again, the counsellor can't change the decision, but they can basically get someone more competent to look at the situation and kind of work out, okay, is it worth us reconsidering? So yeah, I think that's my answer. Does anyone have anything to add to that at all? No, I think, as I say, I think the other thing you can do is complain. And again, the crux of the complaint would be does the council have a contemporaneous record of how they considered that information from the OT and the medical evidence, and when they worked out how many bedrooms that household should be able to bid for. So yeah. Finally, last question is a quick one. So what should I do when my housing officer is not replying back to my emails and to my solicitor's emails? So yeah, basically, if they're not replying to your solicitor's emails, then your solicitor should basically escalate it and get all huffy and puffy and threaten judicial review type stuff, and that will probably do the trick. If you don't have a solicitor, then it comes back to kind of complaining and trying to get a solicitor. But I think if it's important information that you're requesting via email and the council's not doing it, or the council's not kind of complying with general timescales for stuff, then the solicitor should be pretty on the ball there and basically be writing to the council, as I say, potentially threatening legal action if the council doesn't comply with their statutory timeframes. There are kind of time limits on various stages. So, for example, once the relief duty's been triggered, then the council should, in most cases, make their final decision on day 57, and no more than 3 weeks after day 57. So whatever that is in days, 78 or something. So that's kind of like a hard and fast time. So again, you see LGSO decisions which basically uphold complaints because the council took too long to make a decision. I saw one today actually where the family got £2,000 or something because the council had delayed for a year or something making a decision. And by doing that, they also removed their review rights for the suitability of the temporary accommodation and stuff like that. So yeah, that's my answer to that.
Could I add a little bit to that since we've got a bit of time?
Yeah, go for it.
What I tend to do, if it's just routine correspondence that they're not answering, like you send an email and you just don't hear anything back, what I tend to do is have a cycle of 1 week. I think 1 week is a reasonable time to reply if it's not urgent. So what I do is I have a rule of a process. If I write to the council and they don't reply in a week, I forward my previous message to them and say, I don't seem to have had a reply to my message from last week. I'm forwarding a copy to you. Please, can you let me have a response? The next week they get the same thing again, but there's an extra paragraph in bold saying, please note that if I don't receive a response within the next 7 days, I'm going to make a formal complaint about the failure to respond to correspondence and or progress this matter. And then the next one is a formal complaint. The alternative, though, is if it's a reviewing officer, by the time you've gone through that process, which is like 4 weeks, I think, I mean, they've got to complete the review within 8 weeks. So if the reviewing officer doesn't reply and presumably doesn't complete the review, then you can appeal, like I was saying earlier. And so that's what I would add to that one. So just keep chasing them. Give them, I think, 7 days. I mean, it used to be 14 days in the old days before email. But I think now, I mean, 7 days is reasonable, isn't it?
Oh, I mean, it depends what it is, but I'd say
Yeah.
less than 7 seems reasonable to me. If it's like something important,
You
which,
know,
which it probably will be.
Important, but if it's just
Yeah.
sort of, can you tell me what's going on? I think then, well, I mean, I tend to think that's when. Before we go, can I try and answer one more question that Tiff put in there? I think we did touch on it, but maybe I could just add a bit more to it. But I can do it now if you like.
Yeah, go for it. Yeah.
Very quickly, Tiff's put a question. You know, the one that Karis answered about the address on the bank statement. There's a little bit more saying, I think this is the question Tiff's referring to, because Tiff said, did you answer this question? And it says, Tiff's put 2 forms of photo identification, exclamation mark, question mark. And I think if I'm understanding that correctly, there's a sort of suggestion that solicitors are being a bit over the top, or people are, by requiring all this stuff. And the reason for these 2 forms of identification is that a lot of local authorities, you do a subject access request and you straight away get them responding saying, oh, we need 2 forms of ID. One should have your address on it and the other one should have your photo on it. And I'm not sure if they both have to be photo ID. But so the reason that if a solicitor is going to write to the council and ask for your file, which they would need in order to make representations, they're going to get asked for that. So the solicitor usually asks you for that up front, so they don't have to come back to you and delay things. I hope that answers it. I hope that was.
Yeah, that makes sense. Yeah, cool.
Yeah.
Okay. So I think that's it, guys. There's no more questions in the live stream. There's no more questions for the week. So we will return here next Thursday. Will you do anything on yours on Monday?
I'm planning to, yeah.
Cool. So yeah, I'm around on Monday. So yeah. So if you don't come in next Thursday and you want to get something sooner, come to Will's channel on Monday night, 7:30 p.m.
Everyone's
but
welcome.
yeah, other than that, hopefully this has been useful tonight, guys. And yeah, we're going to continue doing live streams through August and stuff. Well, I will be anyway. So yeah, just kind of keep the questions coming. as I say, if you put the questions in during the week, you're going to get a quicker and probably a more organised response as well, because we have a bit of time to consider it beforehand.